My husband died 10 years ago, but yesterday I received a letter from him in the mail. The postmark date, yesterday. Inside, one line. Don't trust your son. Check the basement. My hands trembled as I went downstairs and saw... Good day, dear listeners. It's Louisa again. I'm glad you're here with me. Please like this video and listen to my story till the end, and let me know which city you're listening from. That way I can see how far my story has traveled. My name is Martha Calloway, and I want to tell you about the year I learned that love can be used as a weapon, and that the dead sometimes speak louder than the living. For most of my life, I considered myself a lucky woman. Harold and I built our home in Millbrook, Ohio, back in 1978, a 2-story colonial with a wide porch and a basement Harold used as his workshop. We raised 2 children there, our daughter Pam, who moved to Portland and called every Sunday without fail, and our son Derek, who stayed close. Harold passed 10 years ago, a heart attack, sudden and merciless, on a Tuesday morning in October. I found him in the kitchen still holding his coffee mug. That image never fully left me, but I survived, the way women of my generation learn to survive. Quietly, stubbornly, one day at a time. I was 68 years old, living alone in that house, and for the most part, I was fine. I had my garden. I had my neighbor Ruth, who brought me tomatoes from her greenhouse and stayed for tea. I had my church group on Thursdays, and I had Derek, who lived 20 minutes away and came by every week or two. He was attentive, too attentive, I would later understand. But at the time, I told myself I was fortunate to have a son who cared. The first sign I dismissed was small. Last spring, Derek began asking questions about the house. Casual questions, the kind you might ask over a piece of pie. Mom, do you ever think about downsizing? This place is a lot to maintain. I told him I managed fine. He smiled and dropped it. But he came back to it 2 weeks later, this time mentioning a lovely senior community in Dayton. Just to look at, he said. No pressure. I changed the subject. The second sign was harder to ignore. I noticed paperwork on the kitchen table. I hadn't left it there. A manila folder, just sitting near the fruit bowl, as though it belonged. When I opened it, I found some kind of property valuation form with our address printed at the top. Derek's handwriting was in the margin. I asked him about it the next time he visited. He laughed it off. Oh, that's nothing, Mom. Just something I was looking into for tax purposes. Don't worry about it. I put the folder in the drawer and tried not to think about it. But I did think about it. I thought about it a great deal. The third sign came from Carla, Derek's wife. She had always been polished and pleasant in the careful way of someone performing pleasantness rather than feeling it. But that April, she began accompanying Derek on every visit, and something in her manner had shifted. She watched me, not rudely, nothing you could point to, but with the quiet attention of a woman calculating. She complimented my jewelry twice. She asked whether I had an updated will. She said it with a warm smile. It's just smart planning, Martha. Harold would have wanted you to be prepared. I nodded and excused myself to the kitchen. My hands were cold. I told myself I was being paranoid. Derek was my son, Harold's son. A man I had rocked to sleep, driven to baseball practice, sat beside in the hospital when he had his appendix out at 14. What kind of mother suspects her own child? And then the letter arrived. It was an ordinary Thursday. I had just come back from the church group, still wearing my cardigan, when I found the envelope in the mailbox. My name was written on the front, in handwriting I recognized, before I even fully processed what I was seeing. Harold's handwriting. My heart did something strange, not quite a lurch, more like a skipped beat, like a record scratching. I stood on the porch and looked at that envelope for a long time. The postmark was yesterday's date. The return address was a law office in Columbus, Whitmore and Associates, a name I didn't know. Inside was a single index card, 5 words in Harold's unmistakable blocky print. Don't trust Derek. Check the basement. My hands were shaking so badly I had to sit down on the porch steps. The cardigan suddenly wasn't warm enough. I sat there for several minutes, listening to the neighborhood. A lawnmower somewhere, a dog barking twice and going quiet. And I tried to make my mind work. Harold had been dead for 10 years, and yet here was his handwriting, telling me not to trust our son. I went inside. I stood at the top of the basement stairs for what felt like a very long time. Then I turned on the light, held the railing with both hands, and walked down. What I saw stopped me on the third step. The workshop, Harold's workshop, which I had not touched since he died, had been cleared out. The tools were gone. The workbench was covered with stacked papers, binders, and a laptop computer I didn't recognize. On the wall where Harold used to hang his levels and squares, there was a whiteboard with names, numbers, and arrows drawn between them. My name was at the top. There was a box on the floor, open, stuffed with what looked like legal documents. I could see the words power of attorney printed in bold letters on the top page. I did not go further into the room. I walked back upstairs, sat down at the kitchen table, and pressed my palms flat against the wood to stop the trembling. Something was happening in my house. Something had been happening for a long time, and Harold, somehow impossibly from 10 years in the past, had just told me to look. I didn't sleep that night. I sat in the armchair by the bedroom window, the one Harold used to read in, and I went over what I knew, the way you sort mail. Slowly, carefully, setting things into piles. The folder on the kitchen table, Carla's questions about the will, Derek's talk of senior communities, the cleared-out basement, the binders, the whiteboard. The words, power of attorney on a page that had no business being in my house. By 3 a.m, the fear had done what fear sometimes does when you sit with it long enough. It turned into something harder and colder. Anger, yes, but more than anger. Clarity. Whatever Derek and Carla were planning, they had not done it yet. The paperwork was still downstairs. No documents had been signed. None that I knew of. The house was still mine. My mind was still mine. I had not been declared incompetent. I had not agreed to anything, which meant there was still time. The question was what, exactly, I was dealing with. The following morning I went back downstairs, this time all the way in. I did not touch anything. I had watched enough television to know that you don't disturb evidence before. You understand what it is. I stood in the middle of the room and looked carefully. On the workbench, 3 binders labeled by year. 2022, 2023, 2024. The laptop closed. The open box. I leaned over and read what I could without picking anything up. There were multiple copies of something called a voluntary conservatorship agreement, a document by which a person agrees to transfer management of their finances and property to another party. My name was on these forms, pre-filled, in a font that had been designed to look like a signature field. There was also what appeared to be a medical letter. I could see the letterhead of a doctor I had never heard of, describing a patient with mild cognitive decline and early-stage memory impairment. The patient's name was Martha Calloway. I had to grip the edge of the workbench. Someone had fabricated a medical record. Someone had prepared conservatorship documents. And the documents were here, in my house, in my dead husband's workshop, waiting to be used. I went back upstairs and made coffee because I needed something to do with my hands. I thought about calling Derek. I thought about it seriously. The mother in me kept insisting there must be an explanation, that I was misreading something, that a conversation would clear this up. But then I thought of Carla watching me, of the property valuation form, of Derek's easy laugh when I'd asked him about it. Don't worry about it, Mom. No. If I called him now, They would know I had been in the basement. The documents would disappear. And then it would be my word against theirs. A 68-year-old widow against her son and a stack of papers that no longer existed. I needed evidence first. Real evidence. And I needed someone I could trust. That afternoon, I called Pam. My daughter answered on the second ring, cheerful and rushed the way she always was. But when I said, "Pamela, I need you to listen to me very carefully," she went quiet. I told her about the letter, about the basement, about the documents. I heard her breathing change. "Mom," she said, "don't touch anything down there. Don't tell Derek you know. I'm getting on a flight." "You don't need to." "I'm getting on a flight," she repeated. "Tomorrow morning." After I hung up, I felt something loosen slightly in my chest. Not relief, not yet, but the particular comfort of not being alone. But I did not wait for Pam to take my first step. That evening, I went to my writing desk and found the letter from Harold. I read it again. "Don't trust Derek. Check the basement." The card was cream-colored, the ink slightly faded, old ink, not new. Harold had written this a long time ago, which meant he had known something or feared something. And he had arranged through that law office in Columbus for the letter to reach me under some specific condition. I needed to find out what that condition was. I went to my computer and searched for Whitmore and Associates in Columbus. The firm existed. It had a website, modest but professional, specializing in estate planning and elder law. I wrote down the address and phone number on a notepad the way I used to write grocery lists. Deliberately, pressing the pen firmly into the paper as though making the information more real. My plan at this point was simple. 3 steps in order. First, speak to whoever at Whitmore and Associates had sent that letter and find out what Harold had left behind. Second, document everything in the basement before Derek had any reason to move it. Third, speak to a lawyer, my own lawyer, not Harold's estate attorney, someone entirely new, about what voluntary conservatorship meant legally and what could be done to block it. I was not going to confront Derek. Not yet. Confrontation without ammunition was just noise. I locked the basement door and put the key in my cardigan pocket. Then I sat down and ate supper. Soup from a can, nothing special, because I had read somewhere that you think more clearly when you've eaten. And I needed to think very clearly. Outside, the evening was quiet. The porch light was on, as it always was. The neighborhood looked exactly as it always looked. But I knew now that inside this ordinary house something had been growing for a long time in the dark, and I had only just found the light switch. Pam arrived the next morning on the 7:15 from Portland. I picked her up from the Columbus airport myself. I wasn't about to ask Derek for a ride, and by the time we pulled out of the parking garage, she already had a yellow legal pad in her lap and a pen in her hand. "Tell me everything," she said, "from the beginning." I told her during the drive. She did not interrupt. She wrote things down. When I finished, she was quiet for a moment, watching the highway. "Has he tried to get you to sign anything recently?" she asked. I thought about it. He brought some papers last November, said it was a new healthcare directive, just updating what I already had. I told him I wanted to read it first, and he said there was no rush. He never brought it back up. Pam wrote something down and underlined it twice. That afternoon, the two of us drove to Columbus to the offices of Whitmore and Associates. The building was a quiet brick townhouse on a tree-lined street. We were met by a man named Gerald Whitmore, who was perhaps 60, with the deliberate, careful manner of someone who weighs words before speaking them. He had clearly been expecting my call. He explained with a formality that I suspected concealed genuine feeling that Harold had come to him 8 years before his death, so roughly 18 years ago, with a specific and unusual request. Harold had prepared a sealed letter and left it with the firm, along with a standing instruction. The letter was to be mailed to Martha Calloway if any of several specific conditions were met. Among those conditions, if any attorney filed paperwork naming Martha Calloway as the subject of a conservatorship or guardianship proceeding, the firm's monitoring service, which tracked public filings, was to be triggered. 3 weeks ago, exactly such a filing had appeared in the Franklin County Probate Court. My son had already filed for conservatorship over me. I remember the quality of the silence in that room, the clock on the wall, the sound of a truck on the street outside, Pam's hand finding mine on the armrest of the chair. "He filed," I said, to make it real. "Derek already filed." "A petition was filed on behalf of a Derek Calloway, yes," Mr. Whitmore said. "The petition cites a medical evaluation supporting a finding of cognitive decline." "That evaluation is fabricated," I said. Mr. Whitmore nodded carefully. "That is a matter that would be addressed in the hearing process. However, I would strongly advise you to consult with an elder law attorney immediately, as these proceedings move on a set schedule." He gave us the file Harold had left, not just the letter, but a sealed envelope labeled "For Martha, if this day comes." I did not open it in the office. I held it in both hands on the way to the car, and I felt, very strongly, the presence of a man I had been missing for 10 years. Harold had known. He had not known exactly what would happen, but he had known enough about his son to prepare for the possibility. That knowledge sat in my chest like a stone and like a lamp at the same time. In the car, Pam made 3 phone calls. By the end of the afternoon, we had an appointment for the following morning with an elder law attorney named Sandra Okafor, whose name had been recommended by 2 separate sources as someone who took fabricated medical claims seriously. That evening, we sat at the kitchen table, the same table where I had eaten soup alone 2 nights ago, and I opened Harold's envelope. Inside were 4 handwritten pages. Harold's voice came off them so clearly I had to stop twice and breathe. He had written that for several years before his death, he had noticed Derek making financial decisions that troubled him, a pattern of borrowing that was never quite explained, an interest in the house's equity that felt disproportionate, certain comments that Harold described as testing the water. Harold had never confronted him directly. He wrote that he regretted this. But he had made sure the house was protected as completely as the law allowed. The deed had a specific provision. The will was ironclad. And if things had progressed to the point where Martha was receiving this letter, Harold wrote, then the time for hoping he was wrong was over. "You are stronger than you think," he wrote near the end. "You always have been. Don't let anyone tell you otherwise." I folded the pages carefully, put them back in the envelope, and pressed it flat against the table. "Mom," Pam said softly. "I'm all right," I said. And the strange thing was that I meant it. The next morning, Derek called. He asked how I was, in his usual easy tone, and mentioned he might stop by on the weekend. "Carla wants to bring you some of that lemon cake you like." "That would be lovely," I said. I kept my voice exactly as it always was. I gave him nothing. After I hung up, I sat for a moment and recognized what I was feeling. Not the fear that had been with me for days, but something beneath it that had now surfaced. Purpose. Steady, quiet, implacable purpose. They had filed court papers declaring me incompetent. They had fabricated a medical record. They had been planning this for months, perhaps years, inside the house Harold built with his own hands. Now I had a lawyer. I had a witness. I had Harold's letter. And I had evidence in the basement that they did not yet know I had found. The point of no return, I understood, had not been the moment I walked downstairs and saw the whiteboard. It had been the moment Harold decided to trust me with the truth, even from across a decade of death. He had done his part. Now it was mine. Sandra Okafor was a small, precise woman in her early 50s with close-cropped hair and reading glasses that she removed and replaced with the rhythm of someone who thought very quickly. She sat across from Pam and me in a conference room that smelled of coffee and paper, and she listened to everything without expression. Then she read the documents I had photographed in the basement. I had done it the previous evening, kneeling on the cold floor with my phone, taking clear pictures of every page, and she set her glasses down on the table. "Okay," she said, "here is where you stand." She explained it methodically. The petition Derek had filed was based on the fabricated medical evaluation, which named a Dr. Paul Strickland of Westerville. The conservatorship, if granted, would give Derek legal control over my finances and the right to make decisions about my living arrangements. The house could be sold. Assets could be managed, meaning accessed, on my behalf. This was the plan. But the plan had weaknesses. A fraudulent medical evaluation was a serious matter, potentially criminal. The timing of the filing relative to the documents prepared in my basement created a pattern that a judge would find significant. Harold's letter and the estate attorney's testimony established prior awareness of a threat. And crucially, I had not signed anything. The petition was pending. The hearing was in 6 weeks. "What we need to do immediately," Sandra said, "is file a counter-response to the petition. Submit your own medical evaluation from a physician of your choosing and request that the court appoint a guardian ad litem, an independent evaluator, rather than relying on your son's filed assessment." "Can we go after the fabricated evaluation?" Pam asked. "Yes, but carefully and in sequence. First, we stabilize your mother's position. Then we go on offense." We authorized her to proceed that same day. The action we took was not secret. It couldn't be. It was filed with the court. And so 3 days later, on a Saturday morning, Derek's car was in my driveway before I had finished my second cup of coffee. He came in through the front door as he always had. I had given him a key years ago, something I was already regretting. And Carla was with him. She was carrying the lemon cake, as promised. But her face, when she saw mine, shifted in a way that a cake could not cover. Derek sat down at the kitchen table. He set his keys down carefully, as though making sure his hands were visible. "Mom," he said, "we heard from the court. There was a response filed." "Yes," I said. "I think there's been some kind of misunderstanding." His voice was warm and reasonable, the voice I had heard all my life. "I filed that petition because I'm worried about you. That's all this is. I'm worried about you living alone, and about some things I've noticed." "Derek," I said, "who is Dr. Paul Strickland?" A pause. Small, but I saw it. "He's a doctor I consulted." "I have never been a patient of Dr. Paul Strickland," I said. "I have never met him. My primary physician is Dr. Ann Rivers at Millbrook Family Practice, where I have been a patient for 19 years, and she has not observed any cognitive decline. She has, in fact, provided an affidavit to that effect to my attorney." Carla set the cake down on the counter. The plate made a small, sharp sound. Derek's warmth did not entirely collapse, but it reorganized. "Mom, you hired an attorney?" "I did." "Why would you do that? We're family." "Because family members don't fabricate medical records," I said. My voice was steady. I had practiced this, not the exact words, but the quality of the voice. Calm, factual, impossible to dismiss as hysteria or confusion. "There are documents in this house that your attorney prepared. There is a whiteboard in my basement with my name on it. There are conservatorship forms with a signature field already formatted under my name. I have photographs of all of it." The silence that followed was different from any silence that had been in this kitchen before. Carla looked at Derek. Derek looked at me. "You went through my things," he said. "In my house," I replied. Carla spoke then. And this was the moment I understood who had been driving this. Her voice lost its pleasantness entirely, like a glove turned inside out. Martha, you are making a very serious mistake. Derek has been looking out for you because you cannot look out for yourself. And if you fight this, you are going to find yourself in a very difficult position. Carla, I said, you are in my house. I am asking you to leave. Derek stood up. He was taller than me, and he knew it. Mom, I have spoken to an attorney, I said. I have filed with the court. I have documented everything in the basement. If you would like to discuss this matter further, you may contact Sandra Okafor at her office in Columbus. Her number is on record. I stood up and walked to the front door and opened it. The cake was a nice touch, I said. Please take it with you. They left. Carla did not take the cake. After I heard the car pull away, I stood at the window and watched the street go quiet again. My heart was beating hard. I won't pretend otherwise. But I had not shaken. I had not cried. I had not even for a moment wanted to take it back. Pam came out of the hallway, where she had been waiting, and hugged me from behind without saying anything. I let her. For the next 4 days, I rested. I worked in the garden. I had Ruth over for tea twice. I let myself sleep past 7, which I almost never do. I had fought the first direct battle, and I had not lost. But I knew, as clearly as I knew anything, that it was not over. It was nowhere near over. The call came on a Wednesday, while I was deadheading the roses along the back fence. It was Derek, and his voice had reset itself to something softer. A register I recognized from his childhood, the one he used when he had broken something and wanted to be forgiven before the damage was fully assessed. Mom, I want to apologize, he said. Carla was out of line. We both have been. Can we talk? I straightened up and looked at the garden, at the roses Harold had helped me plant, at the fence he had mended 3 times over the years. We can talk through our attorneys, I said. Mom, please. Derek, I love you, I said, because I did, and because saying it felt important, like keeping something clean. But I am not going to have a conversation that isn't on the record. That's where we are. I hung up and stood in the garden for a while longer. The strange thing was that I felt no temptation, not a flicker of it. Part of me had expected to waver. I was his mother, after all, and the pull of that is not a small thing. But what I kept seeing, when I thought of Derek, was not my little boy in his baseball uniform. It was the whiteboard, my name at the top, the arrows pointing down from it. He called again the following Friday, this time to let me know, casually, as if it were good news, that he had located a very nice independent living community in Westerville, one he thought I would really enjoy, with a beautiful garden and a full activities program. I just thought you'd want to know it was available, he said. Thank you, I said and hung up. Carla sent a text to my cell phone, which I had not known she had, saying that she hoped there were no hard feelings, that this was all coming from a place of love, and that she knew I would make the right decision for everyone. I showed the text to Pam and to Sandra Okafor. Sandra said to save it. I saved everything. What I had not anticipated, and what turned out to matter enormously, was how many people came forward once word began to move quietly through the circles I was part of. Not because I broadcast what was happening. I was careful, strategic about what I said and to whom. But because elder financial abuse is not rare, and those who have seen it recognize it. Ruth, my neighbor, mentioned over tea that her cousin in Akron had gone through something similar 3 years ago. She offered to connect me, which I accepted. That cousin, a woman named Helen, had fought a similar petition and won, and she walked me through what the hearing process had actually looked and felt like, which Sandra's legal description had not fully captured. Helen also told me about a local support organization, the Elder Justice Initiative, run out of the Columbus Legal Aid Society, and she gave me a name there. I called that name. A woman named Diane Forsyth, a social worker and advocate who had worked on dozens of these cases. She came to my house the following Tuesday. She sat at my kitchen table, the same table where all the hard things happened, it seemed, and she looked at everything I had. The photographs, the court filing, Harold's letter, Sandra's filings. She read carefully, the way people read when they actually intend to help. "This is strong," she said. "What Strickland signed, that evaluation, I've seen that pattern before. There's a small network of physicians who will sign these things for a fee. He's been flagged before, but never formally reported." Would a formal report to the medical board affect our case? Not directly, but it establishes a pattern of fraud, which supports everything you're arguing about intent. I asked Diane to help me file the complaint against Dr. Strickland. She did. I also, during this period, had a long conversation with Pam about the deed to the house. Harold, it turned out, had been even more careful than I knew. When Gerald Whitmore had reviewed the estate documents, he had confirmed that Harold had placed the house in a revocable living trust with specific anti-transfer provisions, meaning that without both trustees' signatures, it could not be sold or transferred. Harold had named himself and me as co-trustees. Upon his death, I became sole trustee. Derek had no standing to touch it. The conservatorship petition, if granted, would have tried to supersede this, but it would have been a difficult legal fight even if I had not responded. Harold, it seemed, had been doing what he could not bring himself to say aloud, protecting me, systematically and quietly, against a possibility he hoped would never come. I was sitting at the kitchen table the night I understood the full shape of what he had done, and I cried. The first time since this started. Not from fear, and not entirely from grief, but from the feeling of being loved by someone who was gone, precisely and practically, and from across a decade. Then I dried my face and went back to work. 3 weeks before the court hearing, they came together. It was a Sunday afternoon, unannounced, which I recognized as a deliberate choice. No appointment meant no preparation, no attorney on standby, no Pam in the hallway, just me, alone, in my own living room. I had spent the morning at church and come home to a quiet house, and when I heard the knock, I already knew, from some instinct I had been sharpening for months, that this was not a social call. I opened the door. They were dressed nicely. Derek was holding flowers, dahlias, which had been my favorite, though I had never told Carla that. She had done her research. "We just want to talk, Mom," Derek said. "No lawyers, no court filings, just family." I stepped back and let them in, because you learn more from a conversation than from a closed door. We sat in the living room, the formal one, not the kitchen. I offered nothing to drink. Derek gave me the flowers and I set them on the side table without putting them in water. Carla watched me do this and understood, I think, that it was intentional. The first 15 minutes were soft. Derek expressed regret. He said he had handled things badly. He said that what he wanted, truly and above everything, was for me to be safe and happy. He talked about his father. Carefully, the way you handle something you know can cut you, and said that Harold would have wanted the family to stay together, that Harold had always put family first. I listened without expression. Then Carla shifted. It was a subtle shift. Her posture changed slightly. Her voice took on a practiced reasonableness. "Martha, we just want to be honest with you," she said. "The court process is very hard. It takes months, sometimes longer. It's expensive. It's public. It goes in the record. And for someone in your position, the stress alone can be—" She paused, chose the word deliberately. "Damaging." "Are you suggesting the process will harm me?" I asked. "I'm suggesting it doesn't have to happen at all," she said. "If you were willing to reconsider, To sit down with a mediator instead of going through the courts? We could find something that works for everyone." "What would that look like?" I asked, as though I were considering it. Derek leaned forward, and I saw a flash of something. Relief. Eagerness. The look of a man who thinks the door has opened. "You wouldn't have to move if you don't want to," he said. "We could set up a simple arrangement. Financial oversight, just as a safeguard. Carla and I would manage the accounts, make sure the bills are paid, handle the house maintenance. You'd be free to live exactly as you do. Nothing would change for you day to day. And the house would be protected," he said. Smooth, practiced. "Protected," I repeated. "Of course, we're your family, Mom." I looked at my son for a long moment. He looked back at me with an expression of such genuine seeming concern that I understood, fully and finally, that he had been practicing this for years. Not consciously, perhaps, but the performance was complete. "I would like you to drop the petition," I said. The shift was immediate. Derek's expression didn't collapse, but it hardened like cooling metal. "We can't do that. Then we'll see each other in court." Carla set down her glass. She had helped herself to the water, I noticed, and her voice lost the last of its warmth. "Martha, I'm going to be direct with you. Your daughter is going back to Portland. Your neighbor isn't family. That attorney of yours is going to cost you more than this house is worth by the time this is done. And when the judge sees your file, when he sees the evaluation, when he sees the pattern of—" "The pattern of what?" I said, and there was something in my voice that stopped her. "Of living alone in my own house, of growing my garden, of going to church and having tea with my neighbor, of not signing documents that were placed on my kitchen table when I was out of the room." She was quiet. "Carla," I said, "how did you know dahlias are my favorite flower?" It was a small thing, but her eyes flickered, and in that flicker I saw the shape of exactly how much surveillance, how much calculation had gone into this. She had researched me. She had been studying me for years, the way you study a property before you make an offer. "I'm going to ask you to leave now," I said. For the second time. Derek stood, and for a moment he seemed very tall in my living room, and I felt, I will be honest, a thread of real fear. Not of violence, I don't think Derek would have struck me, but of the particular loneliness of facing someone you love who has become your opponent, who holds all the warmth of childhood and all the cold mechanics of a plan simultaneously. It is a specific kind of frightening. They left, this time without the pretense of a warm goodbye. I stood at the window and watched their car until it turned the corner. Then I went to the kitchen and called Pam and told her what had happened, every detail, while it was still fresh. Then I called Sandra. The fear was still there. I could feel it, a small, tight thing in the center of my chest. But it was doing something useful. It was reminding me what was at stake. It was sharpening me. 3 weeks, I told myself. 3 more weeks. The hearing was on a Tuesday in November, in a courtroom on the 4th floor of the Franklin County Courthouse. The room was smaller than I had imagined. Wood paneling, fluorescent light, the smell of recycled air and old paper. The judge was a woman named the Honorable Patricia Wexler, who was perhaps 60, with silver hair and reading glasses that she used with the same efficiency as Sandra Okafor. I decided immediately that I liked her, or at least that she was someone who had heard too much nonsense to tolerate more of it. Pam sat behind me in the gallery. Ruth was there. Helen, my neighbor's cousin from Akron. Diane Forsyth from the Elder Justice Initiative. They had come not to testify, not all of them, but to be present. I had not fully understood until that morning what it meant to enter a room with people who believed you when you were about to have your mind's reliability contested by your own son. It meant everything. Derek and Carla were already seated when we arrived. Derek wore a dark suit I had never seen before. Carla wore a gray dress that was quiet and serious, designed to convey concern. She had done her research on courtroom presentation too, apparently. Sandra opened by presenting the counter response. My medical evaluation from Dr. Ann Rivers, 19 years of uninterrupted care, no documented cognitive decline, normal scores on every standardized assessment. She submitted the photographs of the basement documents. She submitted Harold's letter and the testimony from Gerald Whitmore about its origin and purpose. She submitted the timeline. Derek's attorney, a man named Philip Graff, who had the confident looseness of someone who had done this many times, opened by framing the petition as an act of loving concern. He spoke about the challenges of aging alone, about the difficulty of adult children watching parents decline, about Derek's long record of involvement in his mother's life. Judge Wexler listened. Then Sandra called her first witness, Dr. Ann Rivers by video, who confirmed calmly and in clinical detail that I had no documented cognitive impairment, that I had consistently demonstrated full orientation and decision-making capacity at every appointment, and that she had not been consulted by anyone prior to the filing of this petition. Then Sandra addressed Dr. Paul Strickland's evaluation. Graff objected, predictably. Sandra was ready. She presented the complaint filed with the Ohio State Medical Board, the prior flagging of Strickland's name in 2 previous conservatorship cases in different counties, and a declaration from a forensic document examiner regarding the date and formatting inconsistencies in the evaluation. Specifically, that the document had been prepared using a template inconsistent with Strickland's practice's documented formatting, and that the patient history sections contained language that did not correspond to any medical record in existence. The courtroom was quiet in a particular way, the quiet of a room where everyone is paying very close attention. Your Honor, Sandra said, the evaluation presented in support of this petition was not prepared based on any examination of Martha Calloway. It was prepared to support a predetermined conclusion. Graff asked for a recess. Judge Wexler denied it. Derek was called to testify. He was composed at first. I had to acknowledge that. He gave measured, concerned answers. He spoke about things he claimed to have noticed. My leaving the stove on, forgetting appointments, repeating stories. None of these things, his attorney had coached him, required documentation. They were the observations of a concerned son. Sandra cross-examined him. Mr. Calloway, when did you first retain Philip Graff? She asked. Graff objected. Overruled. Approximately 14 months ago, Derek said. So 14 months before filing this petition, you hired an attorney specializing in conservatorship law. I was getting advice. You hired a conservatorship attorney 14 months before filing a petition based on a cognitive evaluation dated 11 months ago? A pause. I was being cautious. Mr. Calloway, is the whiteboard currently in your mother's basement yours? Another pause, longer. I use the basement sometimes. Does your name appear on the deed to your mother's house? No. Have you been given written permission to store legal documents there? It's a family home. Does your name appear on the deed? Sandra repeated. No. Did your mother know that conservatorship documents were being prepared in her home? Derek looked at Graff. Graff could not help him. I was handling things. Did she know Mr. Calloway? No. The room was very quiet. Sandra turned to the bench. Your Honor, I would like to submit the deed to the property, which contains the living trust provision established by Harold Calloway specifically to protect the asset from involuntary transfer, and to note for the record that the property has no legal mechanism by which it can be transferred without the sole trustee's consent. The petition before this court would not, even if granted, have achieved its apparent purpose. What it would have achieved is legal control over Martha Calloway's finances and person. Judge Wexler looked at Derek over her reading glasses. Mr. Calloway, she said, did you know about the trust provision when you filed this petition? Derek's composure finally cracked. Not dramatically, not in the way of movies. He simply seemed, in the space of a few seconds, smaller. I thought the trust could be renegotiated through a conservatorship that would give you decision-making authority over your mother. He said nothing. I sat completely still. I felt in that moment the cold clarity I had been building for months. Not triumph exactly, and not satisfaction. Something more like the end of holding your breath for a very long time. Carla, in the seat beside Derek, had gone completely rigid. She had prepared for many possibilities. She had not, it appeared, prepared for the moment when all the layers came off at once in a room where none of them could be put back on. Judge Wexler did not rule from the bench that day. That is not how civil hearings typically work, and I had been prepared by Sandra not to expect an immediate decision. But the judge's closing remarks were not ambiguous. She noted, for the record, that the evidence presented raised serious questions about the integrity of the petition, and she said directly to Derek that she found the sequence of events. The attorney hired 14 months in advance, the documents prepared in the subject's home without her knowledge, the medical evaluation now under formal review, to be inconsistent with the characterization of this matter as an act of familial concern. She announced that she was referring the Strickland evaluation to the Franklin County Prosecutor's Office for review, and that she was appointing an independent guardian ad litem to conduct her own assessment of my situation. She dismissed the petition. Within a week, 2 things happened that had consequences extending well beyond our family. Dr. Paul Strickland was formally suspended by the Ohio State Medical Board, pending an investigation into the validity of 3 conservatorship evaluations he had signed over the previous 2 years. Our case had been the trigger, but we were not the only one. The complaint Diane Forsyth had helped me file had opened a door that turned out to have a great deal behind it, and Philip Graff, Derek's attorney, received a formal inquiry from the Ohio State Bar regarding his role in preparing documents that had been placed in a third party's home without that party's knowledge or consent. I learned later through Sandra that Graff cooperated with investigators in a manner that did not benefit his client. For Derek and Carla, the consequences came in sequence, the way consequences usually do, not all at once but steadily. The Franklin County prosecutor reviewed the referral and, 3 months after the hearing, filed charges against Derek for filing a fraudulent petition and against Carla for conspiracy, specifically for her role in arranging the Strickland evaluation and coordinating the preparation of the basement documents. This I learned from Sandra on a Thursday afternoon in February when she called to tell me that the Callaways had each been served. I sat down when she told me. Not from shock. I had understood for some time that this was where the logic of what they had done was pointing, but from the weight of it. My son was facing criminal charges. That was not a victory I was able to feel cleanly, and I won't pretend otherwise. I had to sit with it. But I also thought of the women and men who had not had Harold's letter, who had not had Pam on a flight the next morning, who had not found Ruth and Helen and Diane, who had signed the documents because they were tired or frightened or because they loved their children too much to believe what was happening. I thought of them, and I understood that what Sandra and Diane and Dr. Rivers and Gerald Whitmore and I had built together was not just a defense of one woman's house. It was a record, a precedent, a set of steps that someone else could follow. Sandra filed a civil suit against Derek and Carla for damages, legal fees, emotional distress, and the costs of the independent medical evaluation. Carla's attorney approached Sandra's office about a settlement 3 weeks in. Sandra, at my direction, declined to settle. We went to civil trial in the spring. It lasted 2 days. The jury deliberated for 4 hours. Derek and Carla were found liable on all counts. The damages award was substantial. Not enough to compensate, as Sandra noted, for the shape of the experience, but enough to matter. Derek's attorney fees were added to the judgment. The civil finding, coming on top of the pending criminal charges, meant that Derek surrendered his real estate license. He had been working in property sales, which in retrospect explained certain things, and that his ability to participate in any fiduciary capacity was severely restricted. I walked out of the courthouse on that spring afternoon with Pam beside me, and the sun doing what Ohio sun does in April, appearing briefly and unexpectedly, as though it had other plans but changed them. I stopped on the steps for a moment. "Mom," Pam said. "I'm fine," I said. "I'm just taking a moment." Harold had given me the truth from 10 years away. Sandra had given me the law. Pam had come on a flight. Ruth had brought tea. Diane had brought experience. Dr. Rivers had told the truth under oath. All of these things had to happen in order, and none of them alone would have been enough. I walked down the courthouse steps and did not look back. The first thing I did, after everything was finished, was have Harold's workshop restored. I hired a carpenter from the church group, a retired man named Bill, who had known Harold slightly, and who took the job as a matter of what he called setting things right. He took everything out of the basement, the binders and the laptop and the whiteboard, all of which had been retained by Sandra until they were no longer needed as evidence and then disposed of properly. And he put back the kind of space it had been: a workbench, shelves for tools, good lighting. I did not put Harold's tools back. Those had long since been given away. But I put other things: my garden planning books, some of my canning equipment, the folding table I'd been storing in the garage. It became, quietly, my space, which seemed right. I planted a new section of garden that spring, along the south fence, where the light was best. Dahlias, among other things. I reclaimed the word. Pam moved back to Portland, but called every Sunday, as she always had, and came for Thanksgiving and a long week in July. The July visit was different from other years. There was less that needed to be said, which made room for other things: long walks, cooking together, evenings on the porch. She brought her partner, Marcus, who had not been to Millbrook before and who was, I decided, a person of genuine quality. We ate well and laughed more than I remembered laughing in some years. Ruth and I fell into a rhythm of twice-weekly tea that we had never quite established before, and it turned out that Ruth was funnier than I had realized. Or perhaps I had simply not been paying the right kind of attention. We planted a shared herb garden along the fence between our properties, which gave us a reason to be outside together and to argue pleasantly about basil. Diane Forsyth and I stayed in contact. I began, the following autumn, volunteering twice a month at the Elder Justice Initiative, reviewing cases, speaking with people who were at the beginning of what I had gone through, answering questions when I could. It was not what I would have expected to do with my time at 68, but it turned out to be the kind of work that makes the days feel weighted in the right direction. Gerald Whitmore, Harold's estate attorney, retired that spring. He sent me a card. I sent him one in return. We had never met before that afternoon in his office, but I felt, and I believe he felt, that we had done something together that mattered. As for Derek and Carla, I will tell you what I know, and I will try to tell it without satisfaction, because I have found that satisfaction in other people's suffering, even people who have wronged you, has a sourness to it that I want no part of. Derek entered a plea agreement on the criminal charges. The agreement included a suspended sentence contingent on restitution and 3 years of supervised probation. He was required to complete a financial ethics course and to have no involvement in any fiduciary or property-adjacent work for the duration of his probation. His real estate license was not reinstated. Carla did not take a plea. Her attorney fought the conspiracy charge and lost. She was convicted at trial and sentenced to 18 months, of which she served 11. I was told, though I did not ask, that she and Derek separated before she was released. Derek called me once, 8 months after the civil judgment, on a Sunday evening. I did not answer. He left a voicemail that I listened to once, standing in the kitchen, He said he was sorry. His voice sounded like someone who had traveled a very long way and arrived somewhere bare and cold. I believed him, in the sense that I believed the feeling was real. Whether it reached the thing it needed to reach, whether it was the kind of sorry that understands rather than the kind that regrets being caught, I could not know. I deleted the voicemail and went back to my book. I did not call him back. Perhaps one day I would. Perhaps not. There are some things that, once broken, require more than sorrow to reassemble. I had not decided, and I did not press myself to decide. I had time. What I did know was this. I was 68 years old, and I lived alone in a house with a good garden and a neighbor who made me laugh, and my daughter called every Sunday. And twice a month I sat with people who needed someone to tell them that they were not wrong to trust themselves. Harold had built this house in 1978. He had also, it turned out, built something less visible, a set of provisions, a chain of trust, a quiet structure of protection assembled over years and sent forward through time like a letter. It had reached me exactly when I needed it. I thought about that often, working in the garden in the early mornings, before the neighborhood was fully awake. I thought about what it meant to love someone carefully enough to plan for your own absence. To say, in effect, I may not be there, but I prepared for this. I am here. The dahlias came up beautifully that first year. They always do, if you give them enough light. I never expected that a letter from a dead man would be the thing that saved me, but Harold knew something I had forgotten. That the people who love us most sometimes see the dangers we refuse to see. If you are living alone, if someone close to you is asking questions about your finances or your home or your arrangements, listen to that quiet unease. It is not paranoia. It is information. And if you are watching someone you love walk through this, be the person who gets on the flight. What would you have done standing at the top of those basement stairs? If this story reached you, if it made you think or feel less alone or more awake, please leave a comment or share it with someone who needs to hear it. Thank you for listening. Harold would be glad you did.